Hello. Today we will talk about the expansion of liability for foodborne illness, from negligence to breach of warranty. When we pick up a package of ground beef or a head of lettuce from the grocery store, we rarely think about legal protections behind that purchase. But over the past century, the law has evolved to protect consumers from something as invisible and dangerous as a foodborne pathogen.
The Centers for Disease Control and Prevention estimates that about 48 million people get sick, 128,000 are hospitalized, and 3,000 die each year from foodborne pathogens in the United States.
Under early English common law, the doctrine of caveat emptor, let the buyer beware, which meant injured consumers had few remedies. Only if a food seller acted carelessly, say by knowingly selling spoiled meat, could they be held liable. But proving that in court was hard. Unless you could prove gross negligence, you were on your own. But in 1852, the American case Thomas versus Winchester cracked that door open. A mislabeled poison sold as medicine caused serious harm. The court ruled the seller could be liable, even though the buyer wasn't the direct customer. Before 1916, you often couldn't sue a maker unless you bought something directly from them. But in McPherson versus Buick, a man hurt himself when a wooden wheel on his Buick car broke, even though he bought the car from a dealer, not Buick itself. The court ruled that manufacturers have a responsibility to make safe products, and can be sued by anyone injured by a defect, not just the person who bought it from them. After McPherson, the idea that companies must act carefully spread to food. When the Uniform Commercial Code came into effect in the 1950s and 60s, restaurants and stores were legally required to ensure the food they sold is safe and edible, even if there's no written contract. This is known as an implied warranty. You're basically guaranteed safe food just by buying it. In 1963, the California Supreme Court took a big leap forward in Greenman versus Uber Power Products. Greenman was hurt using a power tool called a shopsmith, which malfunctioned even though Uber Power Products had been careful. The court said, if a product is defective and hurts you, the manufacturer is responsible regardless of negligence. That's called strict liability. It means injured people don't need to prove the maker was careless, just that the product was dangerous. Today, you've got 3 legal ways to hold restaurants and food sellers accountable. Negligence, if they act carelessly and that carelessness causes you harm. Breach of warranty, by selling food, they automatically promise it's safe to eat. Strict liability, if the food is defective or dangerous, they're responsible, even if they weren't careless. On top of that, FDA rules and the Food Safety Modernization Act, FSMA, don't just encourage safety, they legally require it.